There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
All right, guys. Today we've got another courtroom disaster on our hands. This woman is back in court for violating her probation due to drug use, and instead of accepting legal help like most people would, she decided to represent herself. Yep, you heard that right. Rather than working with a public defender, she chose to go solo and argue her own case. That's usually a risky move, especially when your freedom is on the line. What's interesting is that I'm not even convinced she's a true sovereign citizen. It almost feels like she picked up a few lines from the internet and decided to use them without really understanding what they mean. What do you guys think? Does she actually believe the arguments she's making, or is she just repeating a script she found online? Let me know in the comments, and if you enjoy courtroom content like this, don't forget to like and subscribe. Let's jump right in.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
And just like that, she may have already hurt her chances before the case even gets going. Honestly, I was expecting the usual sovereign citizen talking points by now. You know, the claims that the court has no authority, that laws don't apply to them, or that they're somehow exempt from the legal system. Surprisingly, she hasn't gone down that road yet. But here's the problem. If you're representing yourself, your opening statement is one of the most important moments of the entire case. It's your opportunity to explain your side, establish credibility, and give the court a reason to listen. When you waste that opportunity or fail to make a clear argument, you're essentially starting the game with a huge disadvantage. If you're going to defend yourself, at least come prepared. So far, what do you guys think of her strategy? Let's get back to the hearing.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
Stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
I can't be the only one feeling a little uncomfortable watching this. Sure, she broke the law and put herself in this situation, but seeing someone struggle this badly in court is still tough to watch. That said, it's hard to feel too sorry for her when she had access to legal representation and chose not to use it. The attorney was literally right there and ready to help, yet she decided she'd rather handle everything herself. That's the part one never understands. Why take such a massive risk when professional legal assistance is available? Cases like this are exactly why lawyers exist. Do you guys feel any sympathy for her, or do you think she's getting exactly what she earned through her own decisions? Because things are about to get even worse from here.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief as set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Now, this is where things go completely off the rails. This woman actually argues that she should be paid for the time she spends in jail. Seriously. After violating probation, continuing her drug use, and putting her child at risk, she somehow believes she's entitled to compensation instead of consequences. The level of disconnect from reality here is incredible. Earlier, I felt a little sympathy for her, but that disappeared pretty quickly once this argument came out. When someone violates probation, they're not being unfairly targeted. They're facing the consequences of their own actions. And then there was the comment she made toward the court before being taken into custody. While it may not have crossed the line into an actual threat, it was undeniably disrespectful and completely inappropriate. What stands out to me is how often people with these beliefs convince themselves that simply rejecting the court's authority somehow changes reality. It doesn't. The legal system doesn't stop functioning because someone decides they don't recognize it. At the end of the day, this isn't a person being victimized by the system. This is someone dealing with the outcome of choices they made themselves. The idea that she's entitled to thousands of dollars for time served is pure fantasy. Now that we've watched this entire train wreck unfold, let me know your thoughts. Does she have any chance of turning this situation around, or is she completely out of options at this point? And do you think she'll ever see that $1,200 per minute payout she thinks she's entitled to? I think we all know the answer to that one. If you enjoyed the video, make sure to leave a like, subscribe for more courtroom content, and I'll see you in the next one. Take care.